Hi, Ben.
Hi, Judge.
Ben, nobody from signed on. Can you check with his firm and see if they plan on signing in?
Okay, Judge, because I have emails from them both that they agreed. I mean, they're both. Is it the defendant or is it Saloom or is it
It's Skipworth. I have a
Skipworth?
Nathan Saloom is waiting to be let in,
Right?
and yourself, and that's it.
Yeah. Let me get a hold of her because yeah, she's the one that changed it to 9:15.
Okay, let me let him in and let's see.
Okay.
Let me see if he has an answer. Maybe they settled.
Okay. Okay. I'm still gonna make the call, Judge, and then I'll let you know.
Okay. Mr. Saloom, you just unmute, please.
Morning.
How are you doing, Mark?
Good, Judge. How you doing?
Good. Mr. Skipworth, have you talked to him? He hasn't signed on yet. Do you know if he knows about it or if he's planning to, or? Mr. Loom, can you hear me? No?
I can hear you. Yes, sir.
Okay. Mr. Skipworth, do you know anything about him?
Looks like his he's got it muted. It looks like, Judge.
I'm muted. I'm sorry. You can't hear me? No problem. Can you hear me now? No? No. Can you hear me now? Huh.
Yeah, I can hear you. But it looks like Robert Skipworth, his mute icon is on.
I don't even see him on the screen. You see him on the screen?
I do.
Oh, I didn't even
I
see.
think that's him. Or is that anybody else joining us besides?
Yeah, that's Ben, my part of my staff.
Oh, okay. Okay. I do not see him. I do not see him.
Okay. Yeah, I don't see him either. Hold on one second. We're trying to get a hold of him.
Sure. Take your time.
I'm just gonna. How do I do this? I'm gonna talk to Ben. I'm gonna put you in the waiting room. Just 1 second, okay?
Sure.
Judge. I'm on the line with Attorney Skipworth, and he's trying to log on. He said that he's waiting there. That he's in the waiting to get let in.
Huh. And he has the right. Oh, there it is. There he is. Okay.
He just saw you right now, so he's gonna let you in. Okay. All right. Thanks. Bye.
Okay. Hi, Mr. Skipworth. Can you unmute if you press your red mute button, please? Red.
Yeah, I unmuted it.
There you go. Thank you.
I'm unmuted as well.
Okay. How are you all doing today?
Good. How are you, Judge?
Good. Good.
Fine.
Okay, so we have filed a bill of review. Mr. Skipworth has filed a bill of review. Anything we have to take up before we hear argument?
I don't think so.
Yeah, I filed a simple trial brief. I don't know if you received that.
Yes.
Okay.
Yeah.
We're good.
Okay, Mr. Skipworth, you want to go ahead?
Well, my client found out that he had a default judgment taken against him in your court, and he has filed a bill of review because it was out of time for an actual motion for new trial. So in the bill of review, and this is backed up by an affidavit from my client, Caleb Walsh, he indicates that he was not a client of or a customer of Mr. Saloon. He never had any kind of a contract with him. He never had any kind of a agreement, understanding, anything like that. In fact, he went to Mr. Saloon for title services in order to buy a piece of property for a trust of which he was the trustee. So I don't know what happened, but that sale never happened. And so Mr. Saloon is upset about the costs that he incurred in doing the title work and trying to get things ready for the closing. So he sued my client as an individual, Caleb Walsh. But Mr. Walsh, as I said, is a trustee. He's not individually liable. The trust would be liable. And I've given the name of the trust. And in addition to that, Mr. Walsh never had any kind of a contract, agreement, deal, or anything else with Mr. Saloon. It's kind of like walking into a grocery store and picking up a can of beans and decide you don't want it and walk out, and then they send him a bill for the can of beans. There is no agreement on that, and there is no law to support the fact that a title company, just because they're upset about the time they spent, can sue a customer who doesn't close. But anyway, the problem here is that when my client received the lawsuit papers, he gave them to an attorney to find for him an attorney in El Paso to respond to the lawsuit. The attorney did not do that. In fact, I guess forgot about it, lost it. I don't have any explanation from the attorney. But then Mr. Saloon, faced with this situation where he does not have a response to the lawsuit, went ahead and took a default judgment against my client. So it's that default judgment that my client is attempting to have the court set aside, reinstate the lawsuit, and allow it to proceed on its merits according to what the court finds. Now, in that relation, we have responded. We've listed all of the craddick factors in our motion bill of review. We have a meritorious defense that I've gone over. My client is not at fault for having not answered the lawsuit. And we have given notice to Mr. Saloon. We're trying to get it set aside.
Okay, Mr. Saloon.
Your Honor, the defendant in this case is an absolute fraud, plain and simple. He was duly served, ignored the lawsuit, I guess because of his ego and his perpetual irresponsible behavior, ignored the lawsuit, did get a judgment against him. Not until did I actually file an abstract judgment in his home county of Florida, all of a sudden he comes out of the woodwork, realizing the consequences of his action, and retains local counsel. The fact of the matter is, Mr. Skipworth's argument regarding parties was an argument to be brought up at trial had the defendant answered the lawsuit like he should have answered. The fact of the matter is the client committed fraud. He executed closing documents. And Mr. Skipworth citing no law whatsoever, saying, oh, just because the title company's upset, it's not grounds to sue. That's not a legal theory. What's a legal theory is Caleb Walsh, the defendant in this matter, signed closing documents. Every one of them signed a closing statement that said he's liable for a payment. Then mysteriously disappears. We can't track him down. Lawsuit was filed. He was duly served personally at his house, didn't answer, and now is crying after the fact. Well, crying after the fact is not a legal basis to be granted a bill of review, Your Honor. And Mr. Skipworth has not offered a scintilla of legal argument in support of that.
Okay, in support of what?
In support of arguing for a bill of review being granted here. Why a judgment should be overturned. He's been served.
Well, I think we're here. I think the first threshold is just whether a new trial will be open, not not the merits of the case. Is that your all's understanding?
That is my understanding. I was just trying to offer some context, Your Honor. For bill of review, there's legal standards that the person bringing that motion has to meet. He has not met them in this situation. He was duly served. There was no mistake. He was personally served, failed to answer. Now, not getting on it promptly, not answering, ignoring it is not legal grounds for him to be awarded a new trial.
Mr. Skipper?
Well, Your Honor, his argument goes against our affidavit and the sworn evidence that you have in front of you concerning this matter. We have.
And the evidence you're speaking of is Mr. Caleb's Mr. Welsh's affidavit.
Yes, sir.
Okay, go ahead. I'm sorry.
But I'm saying that's what we're relying on is the evidence that we presented to you in order to get a new trial on this matter.
Your Honor, he was served personally. There's a process server's affidavit in the file. Once again, there was nothing mentioned about anything until I filed an abstract of judgment in his home county of Florida. Until then, lo and behold, it comes out of the woodwork. But ignoring a personal service, not answering a lawsuit is not grounds to be awarded a new trial.
I'm looking for the affidavit. 1 second. I'm trying to bring that up. I'm going to share the screen just to show, get this affidavit up. 1 second. This affidavit, correct? Mr. Skipworth, can you all see that?
That's the correct affidavit. Yes, Your Honor.
I do see, Your Honor. On the surface, Judge, I mean, to show what a fraud Caleb Walsh is, never had any kind of contact with the plaintiff, then how did he sign closing documents for my office? That was number D there. I've never had any contact with the plaintiff. That's patently false. He signed closing documents.
Well, Your Honor, I object. Mr. Saloom is trying to impeach this affidavit. He has no evidence of his own, and so the affidavit stands.
I disagree. There is evidence. There is signed closing documents in the core file. And of course, I'm challenging the affidavit. That's the whole basis of your case. So I'm not going to lie down and accept this affidavit. He patently lied on it right there. Never had any contact with the plaintiff. How in the heck did he sign closing documents then? That's obviously he's lying.
Obviously, he's not, because we have mails, emails, regular mail.
So he never heard of my title office. Just making all this up. That's the basis of your argument, Mr. Skipworth. And then he signed closing documents. We never had any contact with our office. He just signed documents.
Your Honor, I don't need to respond to that.
Because you have no response. That's why.
You all are getting into the merits of the actual case. And what I'm trying to do is just trying to keep this at the first stage of a bill of review. And I'm asking both. The requirements of Craddock would apply, right, for a new trial?
Yes, sir.
And it's 3. Do you have them, Mr. Skipworth, the three-prong?
Well, not right in front of me, but I know that you have to show that the failure to answer is not a result of your inattention, or it has to show that there's been some accident or mistake that prevented you from answering, that you have a meritorious defense, which is I've set up. And I've forgotten the third prong, but I think there are 3.
Your Honor, in my brief, authorities.
1 second, Mr. Sloan, I just have
Sure.
Mr. Skipworth. Isn't if he gave it to an attorney and the attorney's job was to find some, isn't his way to recover. His recovery is against the attorney, is it not?
Well, I suppose that would be one way to do it, but I also was pointing out that it was not his fault for not answering. He didn't do it intentionally. He did not fail to answer intentionally.
Okay. Mr. Saloom, go ahead. I'm sorry.
Judge, I mean, he had a chance to answer the lawsuit. He had a chance when he was notified of the hearing to answer. He didn't respond until there was a default judgment. The standard to get a bill of review, to justify a bill of review and award the party a new trial, is if there was fraud, accident, wrongful act by the plaintiff, or official mistake. That's a standard. The burden is on Mr. Skipworth to show that.
This is your response here, Mr. Saloom, correct?
That's my response. Yes, sir. That's correct. Where he had ample opportunity, Mr. Walsh, to respond. He did it. Once again, only after did he realize there's potential consequences for not responding. He has an abstract of judgment against him. Only then did I hear from Mr. Skipworth. It's made up. I sent it to an attorney. I think that's, a pretty hard argument to believe, in my opinion. And I don't think is a justifiable argument to rule in favor of Mr. Walsh in this case.
Okay. I'm gonna research the Craddock, and anything else you all would like to present or advocate for?
Nothing further.
Okay.
Nothing further, Your Honor. Thank you for your time. Thank you, Mr. Skipworth.
Let me look at, and I'll get a decision to you both.
Okay, thank you, Judge.
Thank you.
Thank you.